While we may not like to think about it too much, death is inevitable. As an advisor, I see so much time spent focusing on saving money, on investing, and then on living the best retirement that all too often the question of what happens when we pass away gets forgotten. I can tell you right now, the risks of getting it wrong are massive, but can so easily be avoided if you know what you're doing. In this video, I'm going to discuss the 5 biggest mistakes I see Australian retirees make when thinking about their estate, and stick around to the end of the video when I'll tell you the biggest secret to the best possible outcomes. Now, the single biggest mistake I see people make is think that their superannuation is automatically included in their will. It isn't. Superannuation is a non-estate asset. The only way it makes it to your will is via one of 2 incredibly special documents. You have to direct your superannuation either to your legal personal representative or to your estate to have any hope of that being captured in your wishes that are outlined in your will or other key documents. So if you don't put one of these documents in place, your super fund or trustee, so if that's Australian Super, then Australian Super will determine where it's paid. If it's an SMSF, the surviving trustee will determine where it's paid, and similar for a corporate super fund. If you don't have this document in place, the trustee will make that payment on your behalf. And I think importantly, only a few people are entitled to get a direct payment of your superannuation. That's mainly your surviving spouse and your children, and financial dependents and other family members at some points. Now, what this document's called is a binding death benefit nomination. And as the name suggests, this is binding on the trustee to pay your superannuation balance to the person that you wish. But it must fit the terms of the trustee and the superannuation fund, and it must be in the appropriate format for it to be considered valid. And this is incredibly important. While making a binding nomination to your estate, or otherwise known as your legal personal representative, can be useful and flexible, you need to be careful in any type of family, but particularly blended families, because these situations can become quite messy and difficult if aren't considered as part of an overriding estate plan. Now, the second key document I want to talk about, and the other mistake, is that a lot of account-based pensions, which we've covered in a previous video, aren't set up as being reversionary to the surviving spouse. And let's remember, death is a compulsory cashing event for superannuation. That means by default, that money must come out of superannuation, unless, of course, there's a binding death nomination or a reversionary pension in place. And a reversionary pension just means that you can continue to receive your spouse's pension for as long as you live, alongside your own pension, but there's something else we'll consider at the end of this video. Now, the key around this is that it offers significant flexibility, and it allows you to maximize the amount held in the tax-free pension cap, which we've covered in previous videos. One of the important things here is that it allows continuity. So if your spouse passes away, there's a risk that bank accounts or other accounts are shut down. The reversionary pension ensures that that won't shut down and that just continue as it was before. Now, this generally needs to be done when you start the pension. In very limited circumstances, or to my understanding, it can't be changed at a point in the future. The third one I want to talk about here is something that is, I think, far too common and has been done far too regularly and creates so many problems when people eventually pass away. And that is that a one-page will just doesn't cut it. It may seem like a good idea, put a will down, we're going to split it 50-50 and we'll get it done cheap, we'll buy it from the post office or the newsagent. But with the average value of Australian houses and growing superannuation balances with the benefit of super guarantee, most estates are likely to be in the hundreds of thousands, if not millions of dollars. And with no inheritance tax, at least at the moment, there's so many options to keep tax at a minimum with a good estate planning strategy. The average house in Australia is worth $800,000 to $1 million, to my understanding. And if this is going to be a portion of your estate, then doesn't it pay to invest a little bit of money, say $3,000 to $6,000, in putting a really clear will that gives great flexibility and optionality to your children? And trust me, given the size of assets, I've seen so many of these go to court. And what people don't always understand is that claims on the estate are funded by the estate, so it pays so much to get it right before you pass. Now, the fourth one I want to talk about is this complex area of joint tenants versus tenants in common. And somewhere where this is incredibly important is in the bank accounts and credit cards run by couples when one member of a couple pass away. Now, there are 2 ways to jointly own your assets. This is not superannuation. Superannuation cannot be jointly owned, but a bank account, a house, a business, basically any other asset. And that's as joint tenants or as tenants in common. In the case of joint tenants, the surviving partner of that joint tenancy automatically gets full ownership of the remaining assets. So if that's a bank account that's held as joint tenants, the ownership of that bank account will simply pass to the surviving partner. Now, the other alternative is tenants in common. In this case, you might have a 50-50 share. It could be 60-40. In this case, your share of this joint asset is distributable in its own right. That is, if you own 50% of your principal residence as tenants in common, one spouse could gift or pass that portion of their assets to their family, and the other spouse could pass it to their own family. So completely distributable. And obviously this can create significant complexity where we're talking about blended families, we're talking about multiple marriages and more complex assets. So in keeping this in mind, when it comes to bank accounts, it's incredibly important that you have both personally held and jointly held bank accounts when one passes away, because generally any bank account held in the deceased's name will close almost immediately, or basically it'd be frozen as soon as the bank finds out. And now the fifth thing I want to talk about, and this is something that people fail to put into their wills, and time again, the amount of people I meet that think they've got great estate plans or great wills in place but don't have this clause included, is that of a testamentary trust. Now, these are massive. They offer the option and flexibility for how your beneficiaries, including your children, are going to inherit. They don't have to be used, and funds can be received directly or they can be received via what's called a testamentary trust. Testamentary trust changes your will from being, say, a 4 or 5 page document to up to 20 pages, because as the name suggests, testamentary trusts don't come into force until the passing of the person who made the will. Why are they so beneficial? There's 2 reasons. The first one is the ability to distribute income and control where that income is distributed. So you can pay it to spouse, your children can pay it to their spouse or their children or any number of beneficiaries named in the deed. But most importantly, your grandchildren get the benefit of adult marginal tax rates. That means if your children inherit a significant sum of your estate and they hold it in a testamentary trust and they have children, they could be distributing up to $18,200 to each child each year without paying any tax. You can imagine this is a significant benefit. And the additional benefit of this, where used appropriately and with the right protections, is that a testamentary trust can offer some protection against issues like bankruptcy and divorce, because the beneficiary doesn't necessarily completely own those assets. Like anything, it isn't perfect and it will depend on each situation. Now, I said at the beginning of the video, I come up with one strategy that will give you the biggest benefit to your estate. And the key is maximizing the value of your estate versus getting all the administration and paperwork in place. And one way to do that is to maximize your superannuation balances, but more importantly, to maximize the tax-free component of your superannuation balances. So like it or not, and however your adult children inherit, now this is mainly relevant to adult children, they will pay a 15% tax on the taxable component of your superannuation balance. That is, the concessional contributions you've made, the salary sacrifice, the super guarantee and related contributions. And there's one way you can minimize the taxable component, and that is through a recontribution strategy, which involves drawing funds from superannuation, generally tax-free, and recontributing them back in as a non-concessional contribution. Now, this can save thousands of dollars in tax for most families, but primarily for those who are going to distribute to adult children. Now, just going back through those again, the 5 key mistakes I regularly see are not understanding that superannuation is not an estate asset, not having a binding death nomination or a reversionary pension in place, having a 1-page will rather than going through a proper estate planning process, not fully understanding the joint tenants versus tenants in common difference, and not having the option for your children and beneficiaries to inherit via a testamentary trust. As always, please reach out to Wattle Partners if you've got any questions regarding your estate plan, regarding your investments, regarding your superannuation. And please comment, follow, and let me know if you've got any questions or areas you want covered.